Copyright principle. Copyright does not subsist in history, historical incidents, or facts. Let us consider the following case, which is Hoehling vs. Universal City Studios Incorporated, 618 F.2d 97, U.S. Court of Appeals for the Second Circuit, 1980. Hoehling wrote and published a book in which he theorized that the crash of the Hindenburg airship in 1936 resulted from sabotage by one Eric Spehl, a crew member who had placed a bomb on the vessel. The defendant film company, with knowledge of Hoehling's book, produced a film which was based on the same theory, and which depicted some of the same incidents as the book. Hoehling's claim for copyright infringement, however, failed.
Below opinions for the court in Rosemont Enterprises Incorporated vs. Random House Incorporated. 1966, we held that the defendant's biography of Howard Hughes did not infringe an earlier biography of the reclusive alleged billionaire. Although the plots of the two works were necessarily similar, there could be no infringement, because of the public benefit in encouraging the development of historical and biographical works, and their public distribution. There cannot be any such thing as copyright, in the order of presentation of the facts, nor, indeed, in their selection. In the instant case, the hypothesis that Eric Spehl destroyed the Hindenburg is based entirely on the interpretation of historical facts. Such an historical interpretation, whether or not it originated with Mr. Hoehling, is not protected by his copyright, and can be freely used by subsequent authors. The same reasoning governs Hoehling's claim that a number of specific facts, ascertained through his personal research, were copied by appellees. Factual information is in the public domain. Each appellee had the right to avail himself of the facts contained in Hoehling's book, and to use such information, whether correct or incorrect, in his own literary work. The remainder of Hoehling's claimed similarities relate to random duplications of phrases and sequences of events. For example, all three works contain a scene in a German beer hall, in which the airship's crew engages in revelry prior to the voyage. Other claimed similarities concern common German greetings of the period, such as Heil Hitler, or songs, such as the German national anthem. These elements, however, are merely scenes auf faire, that is, incidents, characters or settings which are as a practical matter indispensable, or at least standard, in the treatment of a given topic. Because it is virtually impossible to write about a particular historical era, or fictional theme, without employing certain stock or standard literary devices, we have held that scenes auf faire are not copyrightable as a matter of law. A verbatim reproduction of another work, of course, even in the realm of non-fiction, is actionable as copyright infringement. In works devoted to historical subjects, it is our view that a second author may make significant use of prior work, so long as he does not bodily appropriate the expression of another. This principle is justified by the fundamental policy undergirding the copyright laws, the encouragement of contributions to recorded knowledge. Knowledge is expanded as well, by granting new authors of historical works a relatively free hand, to build upon the work of their predecessors.